But there is one part of this bill that hasn't been explained that I think doesn't have that much to do with E-Verify, but it has a lot to do with rights of employers to terminate people and our unfair and deceptive trade practices law. So I'm looking at the bottom of page 5, lines 45 through 50. And basically what this says is, if an employer discharges or terminates an employee, so this is any employee, and it could be for cause. I mean, it could be this person did wrong, but at the same time employs anybody who was, it says here, an unauthorized alien in any position, that the employer, the discharge, even if it was for cause and even if it was a totally different job, has committed an unfair and deceptive trade practice, which of course, gets you attorney's fees and treble damages, and the employee, who could have been discharged for a drug violation, has a right to sue for an unfair and deceptive trade practice. Now that's how I read that section. It doesn't say it has to be the same job. It doesn't say it has to be wrongful termination. It doesn't say, so I don't know what that has to do with E-Verify, but I think that opens up a huge can of worms and is not really the appropriate application of our unfair and deceptive trade practices. So could you first explain why you put it in, and then staff, please tell me if I'm misreading this section.
And I would entertain an amendment to clarify that. I think the intent of that particular section is that on any given day, given a choice of having a layoff or a reduction in staffing, that an employer would have to give preference to the employee who's here legally. And it's, but you do raise a valid point. I think perhaps a clarifying amendment to that would be amenable to us.
President Ross, follow up?
I don't know that I can fix it, so I'm more of a it's in or out kind of girl here.
Well, in the section here, it says on the date of discharge, if someone is released from employment and they hire on the same day an individual. I think it's clear, really.
We do have to get to Representative All right, let's temporarily displace this bill with the amendments drafted, because I do want to get to Representative Womble. We'll get right to
She's almost got it.
Oh, okay, you got it. While we're waiting, let me make an announcement, because there may be people here for this. It's the intent of the chair, especially since it's my bill, to put the whole matter of the tort reform as far as comparative negligence contributed into some kind of study commission and get some of the best legal minds of the state and have everybody who's got an interest to have input, so that we don't do that on the fly during crossover. House Bill 652 is going to wait probably to a meeting we'll hold on Tuesday at some point. All right, the amendment has been prepared. Representative Jackson sends forth an amendment to amend the bill on page 5, line 45 through 50 by deleting those lines. Do all the members understand that section Representative Ross just questioned about? This amendment would remove that in its entirety. Sponsors, would you like to address the amendment?
That's fine. Well, given the qualifications by Representative Ross, I don't object to the amendment.
Is there anything Representative Jackson would like to add? Further discussion and debate on the amendment. Representative Blackwell.
I have a question.
Is it on the amendment?
No.
Yeah, let's get the... Representative Jackson moves adoption of the amendment. All in favor of the amendment signify by saying aye. Aye. All opposed, no. The amendment carries. It's adopted. Representative Blackwell is recognized for a question on the bill.
Thank you, Mr. Chairman. Just to clarify my understanding of the couple things. One is subcontractors have to register and participate in E-Verify without regard to the number of employees they have, right? So if they've got one employee, they are subject to this requirement.
If they have fewer than 25 employees, no.
But subcontractors are defined separately from employer. Employers have to have 25, but subcontractors, I don't see any requirement that there be any number of employees before they meet the threshold. As I see it, if they think they've got a good faith reasons belief that goods or services were intended for use in the contract between a contractor who has to have 25 and a public entity, then they must do this to verify work authorization of new employees. It may not be the intent, but it seems to me the way it's worded, I'm trying to understand from the staff.
Well, the implementation of the bill was precluded until they get to the third stage, and then it would bring everybody in. There will be no outs.
And we'll get an answer by the floor. Is there a motion on this bill? Representative Randall.
Move for a favorable report to the PCS for House Bill 36 and favorable.
Representative Randleman moves that the amendment be rolled to a new committee substitute, that the new committee substitute be given a favorable report, unfavorable as to the original bill. Discussion, debate on that motion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
All opposed, no.
No.
Let's call it division. All in favor, raise your hand. All opposed? What's the count? 5-5, the motion fails for lack of a tie vote. Motion fails.
Thank you.
Next, let's move to House Bill 374. Representative Wamble, eugenic records, public records exemption.